こんにちは。NGB 特許ワールドツアーイギリス編のナビゲーターを務めます NGB の木塚と申します。どうぞよろしくお願いします。今回の訪問先は弊社と長い付き合いのあるイギリスのギル・ジェニングス事務所のロンドンオフィスです。これまでにギル・ジェニングス事務所と弊社で欧州特許異議手続きに関する合同セミナーを駐日英国大使館にて開催したこともあります。本日は2人の知財プロフェッショナル、ロバート・スコーン・ジェームズ弁理士、それからヘザー・スコット弁理士からお話を伺いたいと思います。それではギル・ジェニングス事務所のロンドンオフィスに向かいましょう。Hello, Mr. Scone James. Could you please introduce yourself and your firm?
My name is Robert Skone James, and I'm the chairman of Gill Jennings and Every, and also a partner in the IT and engineering team. I'm delighted to be able to introduce GJE to you, particularly as part of this joint event with our friends at NGB. GJE is one of the most well-known firms of patent and trademark attorneys in Europe, and was recently voted Europe's leading patent firm by the Financial Times. Our main office is in central London, and we have a branch office in Munich, close to the European Patent Office. We have about 130 staff members, of which over 50 are patent or trademark attorneys. We have specialised in advising Japanese firms for over 60 years and have an especially close relationship with NGB and their clients. We understand the special requirements of Japanese clients and teach our attorneys how to handle work from Japan. In particular, we recognise the importance that Japanese clients place in the provision of complex legal advice in clear and simple English and in a cost-effective manner, the need for rapid responses to questions, and the importance of face-to-face meetings. We regularly visit Japan to meet with our clients to discuss their IP issues. We also regularly invite Japanese attorneys to spend time in our office to learn about UK and DP law, and so increase the close relationships we have with our Japanese clients. One topic that we know to be of special interest to our Japanese clients is how well does the UK legal system support intellectual property rights, and will this be affected by Brexit? I am pleased to introduce my colleague, Ms. Heather Scott, another partner in our IT and engineering team, to answer some common questions on this. Let's start with Brexit. How will Brexit affect patents, trademarks and designs in the UK?
Well, the good news is that patents will not be affected. We'll continue to file British patent applications and European patent applications designating the UK, just as we always have done. It will still be possible to obtain patent protection in the UK via a European patent application. And this is because the European Patent Office is separate from the European Union, and the UK is not leaving the European Patent Convention. Trademarks and designs, on the other hand, are going to be affected. So after the 1st of January 2021, European Community trademarks and design registrations will no longer cover the UK. Therefore, to get the same coverage as you do now, it will be necessary to file both a European trademark or design and a British trademark or design in parallel. And at GJE, we'll be able to handle both since we have offices in London and Munich. Luckily, this will not increase the cost significantly because British IP rights are very cost effective to obtain with low official fees.
What's your impression as to how the UK courts view patents? Would you say that they are patented friendly?
Yes, increasingly so, and we expect this to remain the same after Brexit. As an example, in the last 3 years, there have been a major change in how UK courts assess infringement of British patents. We now operate a doctrine of equivalence approach. This means that in some cases, a patent may be found infringed, even where the defendant's product or process does not include a feature required by a literal reading of the patent claim. This may happen if the product or process has a feature which is equivalent to a claimed feature and achieves the same result in the same way as the patent. Owners of British patents are therefore now more likely to be able to enforce their patent rights in the UK than was the case in the past. And while the UK courts first applied the doctrine of equivalence to technologies in the pharmaceutical field, they have since begun considering it in relation to other technologies. For example, last year, a patent relating to plumbing for showers was found infringed as a result of the doctrine.
Are there any other ways in which the UK courts are assisting patentees?
Yes, the UK court has recently shown that in certain circumstances, its decisions can have an impact far beyond the UK. The case in question was a dispute relating to a portfolio of standard essential patents in the field of 2G, 3G, and 4G wireless communications. A third party had been found to infringe 2 of the British patents in the portfolio, and the patent owner was ready to grant them a license under fair, reasonable, and non-discriminatory terms, what we call FRAND for short. This is a requirement when it comes to standard essential patents to ensure that other parties have access to the essential technology. However, the patent owner wanted the license to be a global license, granting rights and therefore receiving royalties in all countries where they had patents protecting the relevant inventions. In contrast, the third party argued that the license should relate to the UK only, since the earlier finding of infringement by the UK courts, of course, related to the UK patents only. The Supreme Court found in favour of the patentee, deciding that in the circumstances, a UK court did have the authority to determine the terms of a global FRAND licence, including the royalty rates. This is very positive for owners of standard essential patents, provided they have obtained protection in the UK. It means that the UK court may assist them in imposing a global FRAND licence on other parties based on a finding of infringement of just the British patent. So this could help them avoid the significant costs of multi-jurisdiction litigation. So this is another good reason for obtaining UK patent protection in order to take advantage of the favourable approach of the UK courts.
What about the patent application process in the UK?
Well, this has also been developed to assist patent applicants in a number of ways. Firstly, filing a patent application at the UK IPO is relatively low cost compared to many other countries. The official fees are low and easy to predict. There are no maintenance fees until after grant, and even then, these are also low. The UK IPO application process is also one of the fastest routes to obtaining a granted patent in the world. In our experience, typically the time from filing to grant of a British patent application is between 3 and 5 years, and that's if no special measures are taken. There are various ways that you can accelerate prosecution of a British patent application if necessary. For example, the UK IPO offers a green channel, which enables applications relating to technologies which are environmentally friendly to be examined faster. We can often achieve grant within just 1 or 2 years. We regularly work with our overseas clients, including NGB, to help ensure any environmentally friendly aspects of the invention are well explained in the patent application in order to make best use of this. And finally, another patentee-friendly aspect of the UK IPO patent application process is that there is no risk of opposition after grant, unlike patents granted by the EPO. This gives patent owners greater certainty that having secured their British patent, it will not be attacked by a third party.
So I hope you found these answers helpful and to hear about the friendly approach of the UK courts to patentees, which will continue after Brexit. I'd like to thank NGB for providing this opportunity to speak to you, and I'm sure they will be pleased to pass on to us any questions that you may have. Thank you.
Thank you very much, Mr. Skone James and Ms. Scott. 以上、お二人へのインタビューでした。イギリスの裁判所や特許庁において、特許権者や出願人に対して有利な動きが出てきているとのお話がありました。ご質問、ご相談がありましたらいつでも弊社までご連絡ください。ご視聴ありがとうございました。